Hi, I'm Chris Walker, Head of Health and Safety at Naptons Health and Safety, and I'm really pleased you've decided to invest some of your valuable time today joining me as we explore some more of your key health and safety responsibilities. The focus of this month's health and safety briefing are the somewhat daunting and often misunderstood reporting of injuries, diseases, and dangerous occurrences regulations. That's RIDDOR 2013. Now, RIDDOR isn't anything new, so you may well be thinking, what on earth is he dragging this one out from the archives for? Well, to be completely honest with you, I still really feel like 2013 can't actually be any more than 1 or 2 years in the past, but there's no denying it, it's getting on for a decade ago. There is, however, a genuine reason that it's back at the top of my health and safety update agenda. Amongst the countless health and safety updates, alerts, and emails that I receive from various health and safety publications, health and safety websites, and the health and safety executive themselves, one headline in particular leapt right out of the inbox at me recently. Amongst the usual case updates on prosecuted organisations, news on workers injured in workplace accidents, and the numerous attempts to sell me one brand of PPE or another, was the following headline: Builder receives custodial sentence for failing to report an incident where a worker was seriously injured. Now, what stuck out for me in the headline was firstly the prosecution of an individual, a person, not a business or an organisation, for breaking a health and safety regulation. Of course, I do spend a lot of time going on and on about the potential for individual prosecutions for health and safety offences. It's just that you don't see one every week, and when you do, it's rarely a custodial sentence. In this case, a 24-week custodial sentence with a few £1,000s of costs as well. If we add to this the fact that the prosecution wasn't actually for the health and safety failings that led to the serious injury, it wasn't the lack of proper risk assessments, the lack of safe systems of work, the lack of training, or the provision of unsafe equipment that gave rise to the prosecution, it was the lack of a notification to the health and safety executive. It is, of course, worthy of note that had the notification been made, then a HSE investigation could have been carried out at the time, and possibly there would still have been penalties for those offences dependent on the findings. In this instance, the individual was charged and found guilty of a breach of RIDDOR. In this case, the guilty employer was a builder, and I fully appreciate that it's highly likely that you are not a builder. However, much like the employer in this case, you're very likely to be responsible for employing workers, operating services, and controlling premises which are used by workers and other people. So in exactly the same way as the builder was, you're a duty holder and responsible person under RIDDOR. If you fail to report an incident where it's required to be reported, these could be the consequences. And while I won't go any deeper into it today, the individual penalties could actually be far worse than this. With this in mind, do you fully understand your responsibilities under RIDDOR? Do you understand what needs to be reported, when and how? Not understanding what needs to be reported is very unlikely to stack up as an excuse for not making the required notification. So be sure to familiarise yourselves thoroughly with the accident and incident reporting, investigation and notification procedures that apply to you. So we know you're legally required to submit a RIDDOR report to the HSE, and we'll touch on the specific scenarios in which such a notification is required shortly. But first, let's do a little bit of a demystify and drown out some of the excitement around RIDDOR reports. Don't forget, of course, that full details on what needs to be reported and when are captured in your QCS accident reporting policy and procedure. So I won't read out the full requirements here. Check out your policy document straight after this for that detail. Firstly, the submission of a RIDDOR notification does not, in every event, result in the HSE sending the full force of its investigative army to your doors. Yes, absolutely, events in which persons are fatally injured or serious harm has been suffered are likely to receive some investigative attention, but this isn't actually the case for the majority of RIDDOR notifiable incidents. The notification itself is not an admission of a failing on your part. Yes, an undesirable event has occurred, but that doesn't necessarily mean you've broken the law. Ensuring the notification is submitted is vital to make sure that you don't, alongside ensuring that the complete necessary investigation is carried out, relevant risk assessments are reviewed, and actions are put into place based on the lessons you've learned from the incident. RIDDOR is ultimately about ensuring the HSE or CQC can get involved in preventing further incidents and occurrences of a similar nature in the future, either through active involvement in serious incident investigations or through statistical analysis of the types of harm encountered in different sectors, highlighting where perhaps targeted campaigns, additional guidance, or changes in regulation may be required. Now, as an employer, you need to report any deaths which result from work-related accidents, certain types of injuries which occur as a result of work-related accidents, cases of work-related disease, and certain types of near misses involving your employees, no matter where they're working. If it's your employee and they're working, when something goes wrong, it's your responsibility. It's your RIDDOR. The types of injuries likely to need reporting are those that are serious or specified injuries, the full list of which you can find in your accident and reporting policy and procedure, as well as any injury that results in absence or inability to conduct normal duties at work for a period of more than 7 consecutive days, not including the day of the incident. Also, if a person not at work, a visitor to your premises for example, suffers an injury for which they are taken directly to hospital for treatment, a RIDDOR report would be required. Just because no one actually gets harmed in an incident doesn't mean RIDDOR won't apply. A long list of high potential consequence near-miss incidents, termed dangerous occurrences, all result in a need for a notification to the HSE. And again, your accident and incident reporting policy has a comprehensive list of such instances. It's important to remember that notifications to the HSE are required to be made without delay and should use the quickest practicable means. Reports are required to be submitted no later than 10 days after the incident, unless it's a more than 7-day absence you're reporting, in which case you have 15 days. Copies of submitted reports must be retained for 3 years. I'd like to thank all of you for taking the time to listen to this recording and look forward to discussing further key health and safety topics with you in the coming months. Thank you and take care.